Good morning, everyone. I'm Katie Furr with Baker Donelson. You're here today for a presentation on fraud and commercial loan transactions, post-judgment legal strategies. This is the third part in a series that we have put on with myself and a few other various Baker Donelson colleagues and third parties. And so we have a great panel today. I've got with me, I'm going to introduce the panel, and then we're going to go over a few housekeeping matters. And so I'll be your moderator. And to tell you a little bit about myself, I'm the assistant managing shareholder of the Atlanta office for Baker Donelson. By way of background, my practice focuses on creditor rights in a variety of bankruptcy and insolvency and commercial litigation context. Over the past 7 years, my practice has largely focused on creditor rights pursuing multi-million-dollar commercial loan defaults with fraud as a major component in the litigated matter. So with me today, I'm going to flip my screen. I have three great panelists. First, I have my colleague down the hall, Kevin Stein, who is a shareholder in the Atlanta office of Baker Donelson. He's licensed to practice in both Georgia and North Carolina, and his team helps clients with matters throughout the United States. His clients include servicers, and other financial service companies seeking his assistance with contract administration, risk management, loan workouts, litigation, and bankruptcy cases. With me today, I also have Lacey Rochester, another Baker Donelson colleague. She's a member of Baker Donelson's corporate restructuring and bankruptcy group and practices out of our New Orleans, Louisiana office and Baltimore, Maryland offices. She's licensed to practice in both states. She enjoys helping her clients formulate practical legal solutions to resolve the challenges of distressed business dealings. She has extensive experience representing various constituents to bankruptcy proceedings and complex commercial workouts and advises on the full spectrum of bankruptcy and restructuring matters in both federal and state court. Lacey also has a focus on a substantial portion of her practice on creditor rights and has previously advised national and regional banks, equipment lenders, financial institutions, real estate finance firms, as well as government-sponsored enterprises in this regard. And lastly, but certainly not least, we have retired Judge William S. Duffy, Jr. Judge Duffy retired in 2018 from active service as a United States District Court Judge for the Northern District of Georgia. From 2001 to 2004, before assuming the federal bench, Judge Duffy served as a United States Attorney for the Northern District of Georgia. Before his appointment as a U.S. Attorney, Judge Duffy was a partner at King & Spalding in Atlanta. He was elected as a partner in 1987. From 1994 to 1995, Judge Duffy left private practice to serve as Deputy Independent Counsel in charge of the Arkansas phase of the Whitewater investigation. He rejoined King & Spalding as a partner following government service. An honors graduate of, I think this might mean Duke University, but perhaps I have it here written as Drake University. In 1973, Judge Duffy received his J.D. cum laude in 1977 from the University of South Carolina Law School. A frequent presenter at legal conferences and seminars on professionalism. In 2023, Judge Duffy's book, The Significant Lawyer, The Pursuit of Purpose and Professionalism, was published. He is working on a second book about professional litigation. Having heard him speak before personally, I can attest to he's a wonderful speaker on professionalism, and the book is also wonderful. He's currently pursuing a master's in theological studies at Nashotah House Theological Seminary. Judge Duffy is married to Betsy Byers Duffy, an author of children's and adult books, and they live in Atlanta and Clarksville, Georgia. So you're joining us today, as I said, as part of a webinar series. The first two series walked us through, with the first series discussing a commercial loan transaction where the financing company or lender, equipment finance company, identified some anomalies in a commercial loan portfolio or an issue with a borrower or vendor that they discovered may have a larger scope of fraud issues. And so we talked through that webinar with the panel about what you can do internally before litigation is pursued, what types of investigation and preliminary tasks you may want to consider as you pursue the investigation into that particular loan or a larger portfolio. Part 2 discussed the litigation of such a commercial loan and whether you can sue on simply, or considerations about suing simply on the contract, for notes and guarantees, or whether, and if you should sue for additional counts like fraud, and sort of what issues might come up within the context of litigation, including, a corollary criminal case. So today we're going to talk about what you do or what you should consider once you have your judgment in hand. And either that judgment might include just the contract judgment or may also include additional counts related to fraud. So before we get into the actual presentation, I did want to discuss a few housekeeping matters. Right now, all of our participants are muted to help reduce the echo. There is a chat box on your screen, and if you have any questions, please feel free to submit a question. We are going to try and leave some time at the end. I did notice that some questions have been submitted prior to today's session. We have looked at those, and we'll try and get to some of them. And if we don't get to your question today, then we'll certainly connect with you offline as to who submitted the question and try and provide you some guidance and feedback. Lastly, this presentation is being submitted for CLE credit, and so you should get an evaluation and some information about CLE subsequently after this session ends. So with that, we'll kind of dive into our presentation. And first, we're going to talk to Lacey about, Lacey, what's one of the first things you do once you've got a judgment in hand? Do you have a particular protocol for, something that is done immediately before any other action is taken?
I do. There's really two main things that I do immediately upon getting a judgment. Number one, first, I get secured if I can. So I want to make sure that my judgment gets recorded in the appropriate state recording office so that I establish a judicial lien against any real, or if you're in Louisiana, immovable property owned by your judgment debtor. That's a quick, easy thing you should do immediately upon getting the judgment. But the second thing that I always do is I get informed. And I want to know what assets does my judgment debtor have so that I can start to turn my piece of paper into actual collection. So the typical way to do that is to look into using a third-party vendor typically to perform asset searches. Sometimes you can do searches that specifically target banks to see, if there are accounts that are flagged that perhaps this judgment debtor has an account at that bank. You can also look at doing asset searches on a national basis or just on a state basis.
Perfect. That's really helpful, Lacey. Do you have just for those that may not have done that, estimate for a cost for a particular bank search for state versus national? And I recognize that the amounts may change based on a vendor that you use.
They do, and also on the level of detail that you're looking for. But typically, state searches can run $350, national can get up to 1,000 or more, again, depending on the level of detail. Another quick, almost instantaneous way to just do a quick search of assets is just Westlaw has an asset search component, and that's free.
Sure. That sounds great. And I'm guessing that well, I guess that's step one, and perhaps we'll kick it over to Kevin to talk about what do you do once you've got this, amount of data identifying potential real estate and or bank assets.
Sure. I mean, a lot of times we already have some inkling of where the judgment debtor banks, because the lender, during the course of the lending relationship may have been drawing out of a particular operating account, or certainly in the credit application stage, the borrower may have disclosed where they were banking at the time. You take that information, you supplement it with an asset search, a bank account search, like Lacey was just describing. And then you look at, jurisdiction. So, there's no way to getting around that garnishments are state by state. There's no one size fits all among the states. I'm licensed in Georgia and North Carolina, but I've handled matters across the country with colleagues at my firm and other firms. So I've had a sampling of garnishment procedure in many different states. And just to highlight what I'm talking about in terms of state-specific procedure, in the state of Texas, the judgment creditor doesn't even get to jump to a garnishment until the judgment creditor certifies to the court that there is upon information and belief, there is no other means to collect the judgment other than through the garnishment. So it's a much more burdensome process in Texas. Contrast that with Georgia, where I'm located, and I've handled most of my matters over the years. We don't have any such restriction. So we take that information, we look at are these banks subject to jurisdiction and venue in the state where we're at? If they're not, we may need to look at registering the judgment where the garnishees are located. But when we're talking about the larger banks, the Bank of Americas, the Wells Fargos, fill in the blank, they usually have a very broad footprint, and we usually have success determining that we've got jurisdiction on the garnishee in the state of Georgia. So one of the nice things about a garnishment is you don't need to give advance notice to your judgment debtor. So, and oftentimes judgment debtors don't prepare for it, surprisingly. And so you can serve a garnishment, you file, and I'll use Georgia as an example, you file an affidavit of garnishment, you get a summons from the clerk, you serve the summons and the affidavit on the bank. Sometimes we serve a registered agent if the bank has a registered agent. Sometimes we can serve a branch manager if the bank has a physical location in the jurisdiction where we've filed the garnishment. And the garnishee, and I'm using banks as the standard garnishee, but in truth, any party that's holding money or other property for your judgment debtor is potentially a garnishee. But I'll use banks to illustrate my point. The garnishee is legally required to freeze the account if it's a judgment debtor with a checking account, for example, and then over a period of days, deposit whatever is in that account with the court, file an answer, serve the answer, and on the judgment creditor, and in the answer indicate, how much money was in the account and has been deposited with the court. So we serve the garnishment on the bank. We freeze the account or accounts if there's more than one. And then in Georgia, we have 3 business days to give notice to our judgment debtor that we've initiated the garnishment. So by the time the judgment debtor has actual or constructive notice of the garnishment process, the accounts have been frozen. And oftentimes that leads to the first productive settlement discussion with the judgment debtor when their funds have been frozen. But short of a settlement, the garnishee deposits the money in the court. The judgment debtor has a limited period of time to file an objection to the garnishment. The objections are very few. The objection is, I don't recognize that there's a judgment against me, or the judgment against me has already been paid off. If there is a timely objection, and we use the term traverse in Georgia, other states, they just refer to it as an objection or an answer. The court will schedule a hearing, and the objection will be argued. It may be an evidentiary hearing depending on the nature of the objection, or it may just be a legal argument. And once the judge makes the decision, if the decision is entered in favor of the judgment creditor, a disbursement order is issued.
Thanks, Kevin. A couple of things I'll add to that. Additionally, in addition to the objections Kevin raised, your judgment debtor may also object on the basis of some statutory exemption, like Social Security or something that was deposited, and that those funds should not, the garnishment fund should not affix to that. Notably, once you as the lender who has gotten, has your judgment in hand established to the court that you have a judgment, then the burden shifts to the judgment debtor or defendant there to establish why the garnished fund should not go to the lender. So it's usually hard for the judgment debtor to come in short of having all kinds of records, which usually these folks are pro se, and they're not prepared. So in our experience, I would say, we've definitely had some success doing this. So I know sometimes it gets exhausting, can look to be expensive, but I always recommend that we at least start there before doing anything else. Lacey or Kevin, go ahead.
I was just going to say one other point, and thank you for reminding me of the exemption issue. But one other point I thought I'd make for the audience. A lot of times we're operating on banking information that may or may not be stale. It's a good chance for us, when we're going to go through the trouble of garnishing a bank, to serve a subpoena. We oftentimes make the decision to serve the bank, the garnishee bank, with the garnishment papers and a subpoena. And the subpoena oftentimes leads us to other accounts. So if it turns out the banking information is stale, in other words, the judgment debtor did have an operating account, but closed the account a few months or some period of time before the garnishment, looking through the most recent bank statements oftentimes is a treasure trove of other useful information, including we look for things like transfers of funds or checks that are deposited into another bank. And that leads us to another bank to follow up with.
That's great. So that's one aspect or enforcement mechanism, the bank garnishment. Lacey, can you chat for a few minutes about wage garnishments? And before you jump in, one of my colleagues in South Carolina just sent a message in the chat saying that South Carolina does not have wage garnishments, but Georgia does. And so if you could chat about the states that you're familiar with about potential wage garnishments, that would be great.
Absolutely. And Kevin, I love your idea of subpoenaing the bank along with the garnishment. I'm going to have to steal that idea. That's a great idea. Yeah, so both Louisiana and Maryland do allow for wage garnishment. One of the overarching benefits of a wage garnishment versus a bank garnishment is that wage garnishments by their nature are continuing. So once you properly perfect one, you're going to be receiving a stream of payments, presumably until the judgment debtor no longer terminates their employment. So, and also, as I think Kevin hit on this earlier, all of these processes are so strictly tied to state law. And so they're all very, very different from state to state. So for instance, to sort of explain that, in Louisiana, we allow wage garnishment, but it's much more governed by the sheriffs versus in Maryland, where the sheriffs are not involved in wage garnishments. So in Louisiana, you would file a petition for issuance of an order directing the wage garnishment of an employer. The sheriff then will serve your garnishment petition, the order, and garnishment interrogatories on the employer, who then has 15 days to answer. And in their answer, because you will have asked them in your interrogatories, they will admit yes or no, whether or not the judgment debtor is employed, the rate of pay, the periods of pay, whether or not there's any property that should not be subject to the garnishment because it's exempt. And then depending upon, they have to file that answer into the record and serve the judgment creditor. At that point, because Louisiana has a two-step process, the judgment creditor then has to file a motion asking for a final order, essentially affecting that wage garnishment. So the order will say, until the debtor is no longer employed by this employer, X dollars will be paid during Y period, and so on and so forth. And so the sheriff remains involved at that point, because instead of sending the money directly to the judgment creditor, the employer is obligated to send that to the sheriff, who probably unsurprisingly collects a 6% commission on every single payment that they process, and then turns over the balance to the judgment creditor. But there are no continuing reporting requirements or anything like that the judgment creditor is obligated to provide once that wage garnishment order is in place. To sort of contrast that against Maryland, it's a little bit similar in that, but a little bit also more formulaic. The judgment creditor will file a request for writ of garnishment with the court, attach a copy of the judgment, and then the clerk of court will issue the writ. Then the judgment creditor is the one that's required to serve that upon the employer. There is no sheriff involvement at that point. The employer will respond, again, providing some of the same information that is the judgment debtor employed. What is their rate of pay? What is their period of pay? Are there any withholdings? And if the employer answers and admits that, yes, we are employing this judgment debtor, at that point, it can start to just pay the creditor directly. Now, in Maryland, unlike Louisiana, there are certain post-garnishment reporting requirements that the judgment creditor is required to comply with as it receives its portion of the wages. And one other thing to be concerned about with wage garnishments is that there are some federal restrictions about how much you can collect from an individual. Typically, it's no more than 25% of disposable income. So you might not be able to get the big quote unquote hit that you would get if you garnish a bank account and there's $100,000 sitting in it. But the benefit to wage garnishments is it is a steady stream of payments.
Thanks, Lacey. That's great. And I'll just give the audience, for those that are, kind of keeping track for different states. Georgia, we file it with the court. If you do, there's a timeline where you have to renew your garnishment, but the funds are then tendered to the court, and then there's a disbursement process for the judgment creditor to seek the funds. I have dealt with garnishments, wage garnishments, through other states where it's a hybrid process where you file the garnishment with the court and then the employer sends funds directly to the judgment creditor. So as Lacey mentioned, very state specific, but if you're looking to pursue that, we can certainly assist in doing that. But it's also obviously a very common tool that I suspect all of our loan officers or recovery officers on the phone are familiar with. But perhaps one strategy that people are less familiar with is the seizure levy process, which is also unique to each state. But we'll have Judge Duffy chat a little bit about that because it's sort of the non-traditional path of the garnishment path. So Judge, can you give us a little guidance on your experience or recommendations with regard to considering a sheriff's seizure or levy?
I'd love to do that. But before I do, let me just say that I think the value I might bring to this conversation, since we've already talked about processes in which courts ultimately are involved, is to give you a little perspective on what a court considers when you get to this very different, less formulaic process where a decision has to be made by a judicial officer. And I would urge everybody when they get into any matters of this sort that they consider that ultimately, if you go to a court's going to have to balance the interests of an institution against the interests of a business or a person. And to begin looking at this as from the perspective of the court, which is what would the court want to know and what would the court expect of the lawyers being presenting to the judge of their conduct and the information that's necessary for them to do this balancing process. And I can't underscore, I want to underscore how important it is that when you're before a court and not knowing who the judge is or what their proclivities are, that there often is a desire to make sure that the decision they're making is right and that it protects the interests of the property holder and debtor. And I think that gets lost sometimes because by the time you get to the court, the client is probably frustrated, the lawyers are probably frustrated, and the sense is that we're going to the court because you are to relieve of our frustrations. And you might not take into account what the court wants to know is, am I about to enter an order that makes the right judgment under the law and is fair to the people that are involved in the process? And so let me give you an example of a different kind of levy and how that operated. And this was from the time that I was in private practice. We represented a large manufacturer of motorcycles. And they were, the floor financing at one of the dealerships was in default. There was a judgment, and the asset, after realizing that there were very few funds available to satisfy the judgment, were the motorcycles that were offered as security for the loan. And I was asked to take care of the levy, which I had never done before. And so I went and looked at the statute. And then I realized that there was, in fact, a viable business at one time that was selling motorcycles to interested customers that they had, until they got into financial problems, a good reputation within the city. And we were not only about to close the dealership, but we were about to close the repair facility. And so when I talked to Suzuki and their lawyers, they were interested as quickly as possible in making sure that they got the motorcycles and that they were seized, and they had a process for doing that because they'd done it before. But they were also concerned about what the public perception was going to be of the actual seizure, since it would be very public. And secondly, what the reaction were going to be of people that had bought their motorcycles at a place where they were getting them repaired. And so we had a long discussion about making sure there were no glitches in the process. And I decided that while the court wasn't required to issue the levy notice, that we knew who the court was that had the case, and that we were going to advise the court after we had prepared all the paperwork and had prepared a short summary factually of the default, that we were going to provide that to the court for informational purposes, so that when an order was signed allowing the motorcycles to be seized, that he was aware that if anything should happen during the course of the seizure, that he had some awareness that it was going on, and on what day it was going on, and at what time. And then we had a long conversation with the two deputies that were assigned to go with us to execute on the judgment and the acquisition, the levy order, about what we knew about the location and what we knew about the owner and the person who was the debtor. And they became a lot more cautious about the manner in which they were going to go about the actual seizure. One, they talked at length with the people who are actually going to physically seize the motorcycles, and that they positioned themselves at places where they thought that if there was any threat as a result of the seizure, that they would be able to respond in a way that would protect the public, protect the people doing the seizure, and protect the property. They insisted, for example, when we went to the dealership, that because it was locked, that there be no damage to any part of the facility except for the removal of the locks, and the Suzuki was prepared with a locksmith to have the lock open without any damage to the property. And then they went about seizing these almost 100 motorcycles and putting them on tractor trailer trucks, but doing them, they said, less quickly than they would normally do it, so that they could be vigilant about being in this very public place and not knowing everybody that was around. And we noticed halfway through the seizure that there was a black car parked across the street that would travel back and forth, and identified the person as the owner of the dealership, and didn't know what his intentions were, whether they were just a watch or whether there was mischief that he was thinking. And ultimately, when all the motorcycles were seized, we took pictures for the court if ever the court wanted to see what the seizure was like. We had videos of the seizure. We made sure that the sheriff's deputies were evident, that we were prepared if he wanted to know how it went to show him that information. And ultimately, there were no problems. And ultimately, the discovery was that the debtor had no assets to satisfy the deficiency. But because he thought that it was done in a proper way, they ended up over a very long period of time entering into an agreement to repay the amount that was owed to Suzuki. So I just think being thoughtful about this process is important.
Thank you, Judge. I can tell the audience that in our pre-call, Kevin, Lacey, and I thought that practical advice was fantastic, since it's a less used method, and I really appreciated intentionality before that everyone gave to the process, especially Judge Duffy, before you embarked on the process. And that's something that we all intend to use in our practice, because each, sheriff's office and state authority is so different. And to know that you've thought through it so that you can answer those questions and present it to the judge is really thinking ahead. And I think it reduces a lot of potential issues. So a lot of good information there that I really appreciate, that I think that I will plan to use in my practice. So Kevin and Lacey, sort of building off what the judge just said about, now you have the items, the equipment. If you have to use the sheriffs for such a sale, which I know enough about Louisiana that the sheriff is always involved so that he or she can get their portion of the fee. Can you walk through sort of what the process is in Louisiana for such a sheriff sale for perhaps unencumbered property, and compare that with Maryland?
Sure. You're correct that, well, I will start off by saying this is actually one of those areas that Maryland and Louisiana are actually quite similar. It's just mostly a difference in terminology. We seize under a writ of FIFA in Louisiana. It's a writ of execution in Maryland. Both processes involve the sheriffs. Both processes allow a creditor to credit bid. Both processes have the sheriffs taking the lead on properly advertising for the sales. And both have statutorily set costs and commissions. If I had my choice, would I want to have a sheriff sale in Maryland versus a sheriff sale in Louisiana? I would probably pick Maryland, simply because the commissions are lower. In Maryland, on personal property for the first $5,000, you're looking at 3%. For the next 5, it's 2. And then for anything over 10,000, it's going to be 1%. For real property, you start at 1.5% for the first 5,000. Then you go down to 1% for the next 5, and then 0.5 for anything above $10,000. So, most of the time when you're seizing these types of assets, you're going to hope to get more than $10,000 worth of proceeds. So, you're not looking at a high level of commission in Maryland versus Louisiana, where you've got to deal with this 3% for immovables, which is real property, or 6% for personal property. One pro tip I would advise the audience of is you really need to focus on being specific when you're communicating with the sheriff. And that's sort of what Judge Duffy was just getting into. But you want to make sure that you give the sheriff foolproof instructions. What is the asset? Where is it located? How would you like them to conduct the seizure? Would you like them to seize it in place? Is this the type of thing that you would instead would like the sheriff to recover and hold pending the sale? And relatedly, how much is it going to cost to have the sheriff hold this asset versus just seizing it in place? Sometimes you can get into trouble if it's going to be, both sale processes in Louisiana and Maryland are relatively quick. You can get through them within a month to 2 months. However, if for some reason it might be a little bit longer until you get to the sale, perhaps you want to continue the sale for some reason. If the sheriff has a buddy down the road that's storing your tractor trailer, those storage fees can get expensive, and the sheriff will certainly want to deduct those prior to turning over any proceeds. So I think early and often communication with the sheriff from day one during this process is essential to achieving the best outcome.
I think that's great. And as a practical pointer, in Georgia, we do try and call to know what you need in your letter. We do try and call, just like Judge Duffy was encouraging, that collaborative process between yourself and the sheriff's office to understand and preview what the issue is, so that you can put it in writing as a follow-up for exactly what they need, because they know that the front desk person is going to get the letter and where to route it and how to take it from there. I will say you can't always get anybody to answer sometimes at the sheriff's office, but as long as you're trying, I think that's the best approach. And at least you can relay that to your client team that, we attempted to try and, work through this with the sheriff on the front end. And so that should reduce some issues going forward. Kevin, would you mind sharing a little bit about the Georgia process compared to the North Carolina process as compared to what Lacey was just suggesting?
Sure. And I'll say in both states, you can ask the sheriff to sell any kind of property of the judgment debtor, personal property, real property. In theory, in practice, at least for me, it's extremely rare that the facts lend themselves to asking a sheriff to sell personal property. So where I've, over the years, engaged with the sheriff's office, more often than not, it involves real property. The good news, Georgia, we're proud of saying we're a business-friendly state, whether intentional or unintentional. That mantra carries over to sheriff sales. And what I mean by that is we don't have any fees or commissions like what Lacey was outlining in the states where she practices. There is a statutory fee, a nominal statutory fee, but the sheriff is not getting any kind of commission for selling real property subject to a creditor's judgment lien. Now, that's the good part. The bad part is we have 159 counties in the state of Georgia, and each county may have slight variations in how the sheriff's department wants the creditor to request and provide paperwork in support of a sheriff's sale of real property. So as Katie alluded to, you get on the phone. In fact, we've had counties in Georgia where the sheriff's department has said that the deputies we've spoken to have said they've never done one before. In some of these smaller counties, for whatever reason, they had never conducted a sheriff's sale. And so in those instances, we walk them through the process as we understand it. I've had occasion to contact county attorneys and ask the county attorneys to connect with the sheriff's department, help guide the sheriff's department. But the bottom line is you follow the lead of the local sheriff in the jurisdiction where the property is located. In the metro Atlanta counties, I expect that I'm going to be providing a title exam. They're going to want to see that the judgment debtor has good title. They're going to want to see a vesting deed. They're going to want to know if there's any other liens. They're going to want to know if the judgment lien is the first lien. But once you satisfy the sheriff's department, they will proceed with the sale process, much like a non-judicial foreclosure. So there'll be an advertising period of 4 weeks. There'll be a sale on the courthouse steps. And the judgment creditor, this is very important, can credit bid. And so I've had an instance where, just using one example, there were no other bidders. And we were selling a condominium in the city of Atlanta. And I had a judgment in hand, and I credit bid $500. And $500 was the high bid. And my client ended up taking title and then ultimately reselling it down the road to further collect on the judgment. But when the dust settled after the sheriff's sale, my client had the full amount of judgment to collect still, minus $500, and title to a condominium.
It's a great result, Kevin.
Can I
go ahead, Judge.
So let me take a larger, more valuable piece of property. This was when I was the United States Attorney, and we had seized a strip club after a forfeiture was made for the defendants that owned the strip club. And their lawyer was a reasonable fellow. And we had the right to seize it and sell it, but it was a very, very bad real estate market. So he came to us and he said, does it really make sense? Because whatever value you don't get out of this sale, it's still going to be a requirement of the defendant to pay it. And over time, he probably could pay a large portion of it. He said, but wouldn't it be in your interest if you wanted to get more money on the front end of the sale? And it certainly would be in our interest, and he was upfront about that, if we could wait until the market improved. And ultimately, there were some people in the asset forfeiture division that wanted to just sell it. And I said, I didn't think that made any sense for the citizens. And so on a rolling basis, we said, let's hold it for 6 months, and then 6 more months. The market improved, continued to improve, and we ended up selling it 2 years after we had the right to sell it. And both parties, especially the government, really benefited from waiting until the market improved to make the sale. And I think it's those sort of practical considerations. And where you have a condominium, if there's some way that you could reach some sort of agreement or hold the property, if that's possible, if you even want to, until a market improves, that might be to everybody's benefit, especially the creditors.
Judge, that's a really good point. I'll say it reminds me of Lacey's comments at the beginning of this presentation about, making sure right out of the gate that you take your judgment, you perfect your judgment lien on the real estate. And once you perfected your judgment lien, you have the ability to consider timing. Judgments are valid, depending on the state, 7 years, 10 years, 20 years. There's processes to renew judgments. Obviously, nobody wants to wait 10 years, but the point is practical considerations of, considering the market and is it prudent I almost said foreclose. Is it prudent to have the sheriff sell this property now or maybe wait a little longer? You have that luxury. Once your judgment lien's in place, the judgment debtor with title to that property, really, their hands are tied. They can't refinance it. They can't sell it without dealing with your lien. And so, we've had liens in place for years, and our client has decided, we have no interest in going through a sheriff's sale. We're going to leave our lien in place and see what happens. Every year, I get a call from a title examiner or a closing firm. We need a payoff on this judgment. So-and-so is now looking to sell the property. The market has improved. So-and-so thinks that there's now equity above and beyond the judgment lien, and we give a judgment lien payoff. And then sometimes we negotiate that down, but we don't rush to sell the property. We play the market.
All great points. And I was going to add two things. One is that once you have your FIFA on file, if there's a fraudulent transfer, a conveyance, we have rights, and we'll discuss that later in the presentation about fraudulent transfers. So it's not like you're out of luck, of course, if the property is fraudulently conveyed, notwithstanding the FIFA on file. And then I've had success, and I know Kevin has as well, is, we know that sort of the sheriff's sale is a tool in your toolbox, if you will, for enforcement of your judgment. But I use that as an opportunity. It strikes a different chord when your judgment debtor gets a letter saying, we know you have these properties that are unencumbered or that we can easily, satisfy the encumbrance with and still, get a good share of the proceeds here. So we intend to sell, and we're going to do that unless, we hear from you within X days with a meaningful settlement offer. And I will say that changed. I alluded to, some of my fraud work in a case that had been ongoing for about 7 years. That was sort of the shift when we said we were going to sell the marital home via sheriff's sale. That is what prompted the parties to start engaging in meaningful settlement discussion. And then I've had a pro bono case where, again, that we got nothing for years, and then finally, that type of relief and suggestion we were finally advertising for was enough to be a turning point. So I think this is a great tool to consider either through settlement negotiations or actual, the actual process. You may end up with a condo and bucket for $500. One last sort of tool or mechanism that we might consider that I've had mixed success with, so I look forward to the responses here, charging orders. So Kevin, is there a way to get to judgment debtors' compensation or distributions in a closely held company if they have an ownership or membership interest? And what is that called, and sort of what's the process that you're familiar with?
Sure. We talked about wage garnishments earlier in the presentation, but if our judgment debtor is an owner of a company, then as everyone knows, there's more than one way to get money from the company. Wages is just one. Distribution of profits, and I use profits in quotes, is another way an owner can take money from a company. If the owner is a judgment debtor, if the company is a limited liability company, every state that's adopted the Model Limited Liability Company Act has a process for securing a charging order. The charging order, I've always understood it as a loose equivalent as a continuing garnishment. Basically, it's an order entered by a court that has jurisdiction over the company, and the order directs the company to redirect any form of distribution on account of the judgment debtor's ownership in the company to the judgment creditor. Now, a couple limitations. There's no equivalent for corporations. Charging orders are unique to limited liability companies. Limited liability companies nowadays are far and away the most common form of business association. So it's a very useful tool, but it's important to note that there is no such thing as a charging order with corporations. What you can do with a corporation is have the sheriff sell the stock. That goes back to the sheriff sale discussion we had a few minutes ago. But if you're talking about a limited liability company, your best opportunity to claim the distributions over time until the judgment's been paid is through a charging order. The other limitation, though, is when you're talking about a closely held company, you're talking about, this is the classic scenario of, the fox guarding the hen house. So, I've had many instances where the judgment debtor is the only owner, or is a majority owner, or is one of few owners, all of whom are, family or otherwise closely aligned. And now the company is being, charged with taking money out of this judgment debtor's hands and directing it to the judgment creditor. And as you might imagine, enforcement becomes an issue. So what we do there to keep everyone honest as best as possible is we apply for the charging order, and we get the charging order, and we subpoena the company for historical distribution data and banking information, et cetera. And we really take a look at what are the distributions been in the recent past before the before the charging order was entered, and what can we expect going forward. And if we don't see money coming in, we're following up, we're sending letters, we're threatening subpoenas. One thing that creative companies and judgment debtors have tried to do, I've seen this happen. You got two owners, one of which is your judgment debtor. One owner's, the one who's not a judgment debtor, is taking distributions. The one who is the judgment debtor is deferring distributions to try to stay ahead of the charging order. Unless that was the setup of this company when this company was established, and you look for the operating agreement of the LLC, that is not appropriate. Distributions, all things being equal under every Model Limited Liability Company Act, are proportionate. If you give a distribution to one 50% owner, you got to give it to the other. There's no such thing as deferring it, but it's something that they'll try to do. And then what we do is we end up moving to compel, or we move for contempt against the company, and we let all this play out in front of a judge. And these are the things that I do to kind of keep the people that are around my judgment debtor honest as best as possible.
That's a great segue.
Kevin,
because,
can I ask you one thing about that?
Go ahead, Judge. I was going to kick it over to you anyway.
Can you get a charging order against a partner in a partnership, or a limited or general partner in a limited partnership?
Judge, that's a great question. And Lacey and Katie, I don't know. Honestly, I don't know the answer. I lean toward there not being the equivalent for partnerships because I haven't seen it in my own personal practice, and I've been doing this a long time. But candidly, I'm not 100% certain. I don't know if Katie or Lacey have looked at this.
I would I'm not sure, certainly in Louisiana, what the answer to that is, because charging orders in Louisiana are so worthless as it relates to remedies that if it doesn't work for an LLC, why try it with a partnership?
Yeah, and I don't unfortunately know the answer to that. Judge, did you see any of these types of charging order matters come before you while on the bench? Because enforceability, I think, is obviously that's the crux, and if we can't get in front of the judge to get some oomph behind it, then they're kind of meaningless.
You know, with the limited federal jurisdiction in civil matters, I don't recall ever having a charging order issue, although there were a couple issues where a limited partner owed money on a loan that was separate and apart from the loans that were attached to the limited partnership. And I had a case where there was somebody who had a judgment that was a partner in a law firm, and never considered how that would be enforced in my court after the judgment was entered. But a limited partner gets a distribution based upon what their percentage share is, and their distribution is related to their specific share. So it's once you you sell a company within the limited partnership, you have a fixed amount of money, absent administrative expenses, that have to be distributed to the limited partners. And that's easily calculatable. I just don't see why you couldn't attach that as an asset, or at least enter into an arrangement for that to be done. But I will say that the only cases I've had where I've really gotten involved in disputes between monies that were owed by a debtor, had a judgment against them, where was the savings and loan and banking debacle in the early 2000s. And it was interesting how often the person who had a judgment entered against them would show that they didn't have control and didn't have a right to deliver property that the creditor was claiming that they owed, and had an obligation to forfeit. And I would just say the practical note is that if you have to go and have a court enforce that, you need to make sure that you have, for the judge, a clear indication as to what the authority is and the control that the debtor has to satisfy a judgment by delivering that which the court can be convinced they are required to deliver.
That's great advice. Kevin, were you going to say something?
I was just going to say, Judge, for what it's worth, and audience, for what it's worth, I just ran a generative AI search on my computer. And, and the results I got are that there is such a thing as a charging order on a limited partner's interest. Obviously, you'd want to look at in the state you're in, you'd want to look at the act that governs limited partnerships in that state, and see what you find. But that's what Google tells me. One other point, we can move on, but I do want to emphasize that with LLCs and potentially limited partnerships, a charging order is, really, targeted toward distributions and kind of seizing those distributions that would otherwise be directed to the judgment debtor. But it does not, it's not the same as sort of having a sheriff sell stock, your judgment debtor's stock ownership in a corporation. There's no method by which the judgment creditor can, acquire all of the bundle of rights of a LLC member's interest to collect on a judgment. So you can get a charging order, but you really can't do a whole lot more than that. Whereas, with a ownership in a corporation, you actually can have a sheriff sell the ownership, and you can credit bid. And really transfer ownership, which includes, the right to profits, the liquidation rights, et cetera, management rights. But so it's two very distinct sort of methods of collection when you're talking about corporations versus LLCs.
Great distinction.
That's a great point, Kevin. In Louisiana, that's why charging orders are so ineffective, is you don't get the rights of a voting member. It's just passive ownership.
Thanks, Lacey. So I know our audience is probably looking at the clock thinking we haven't hit several topics that were on the invitation today. And so in our pre-call, we decided there was so much good information here that we thought that we actually think it's best to break this up into yet another webinar where we will be talking about discovery tools, for example, written discovery, depositions, discovery to third parties like spouses, issues that might arise for enforcement of that, like motions to for contempt and to compel. And then a great topic that I'm excited to discuss, particularly with Judge Duffy, is settlement and mediation strategies, and then like alternative recovery strategies with alter ego lawsuits and fraudulent conveyance lawsuits. So, but wait, there's more. That is in our next webinar with a date to be announced, likely after the holidays. And so with that caveat, I think we haven't been able to leave time before, and so I'm excited today to address some of the questions that we see. And I saw one pop up in the chat box, and I'll go ahead and address that. It was a great question. It's asking, do we, I assume Baker Donelson, have a particular subpoena form that we use to find transfers that a debtor may be making in their bank records? And so I'm happy to answer that. Yes, we often have forms, and it may not be within the subpoena to the bank garnishment subpoena. Typically, we include the documentation together, so the bank will get a bank garnishment summons, and then additionally a written, either a subpoena for documents or in Georgia, a request to produce, whatever one we decide to do, and they're sort of delivered to that bank at the same time. And yes, we have a form type of list of requests that just ask for, any statements or loans, applications, sort of your standard request for information for any of your judgment debtors based on their socials or EINs. And then the bank will provide you with that, and you can sort of then trace and look for transfers that you might otherwise not have known about. And of course, if you get bank records from a judgment debtor at a contested garnishment hearings, that's a bank you're going to request information from using one of our form subpoenas or requests for documents to identify additional information about their banking habits. I saw my South Carolina colleague again noted, just for the audience, that in South Carolina, when you have a judgment, the judgments there are good for 10 years, but unlike Georgia and other states, there's no renewal of those judgments. So you get 10 years to find what you can find, and then that's it. And so just wanted to alert the audience members with loans that they're enforcing or judgments that they're enforcing in South Carolina. One great question that was submitted that we're going to need a little bit more information on from the submitter before the session was, how can selling off of our application on the secondary market be addressed? And so the panelists discussed before this presentation, and if you submitted that question, I'd love to hear a little bit more about with a little bit more particularity about what you were concerned about. Internally, the panelists were talking about whether that's a reps and warranties matter where, you might want to beef up reps and warranties in a potential APA sale of that portfolio. And then Judge Duffy raised a good point about, what does that mean for due diligence from the seller side when they are undertaking, their due diligence on loans, knowing that they're eventually going to sell or syndicate that loan package. So we'd love to hear a little bit more about your question, and then perhaps we can put on or get back to you, or maybe that will become part of a subsequent webinar down the road. Another question that was submitted or topic was involvement of law enforcement. So for the person that submitted that topic, if you want to submit a follow-up question with a little bit more particularity, I wanted to mention that part 2 talked about the enforcement, like sort of the criminal and civil parallel paths in litigation, and perhaps how law enforcement becomes involved in pursuing a fraudulent loan. And then additionally here in this topic, we just mentioned how we use law enforcement for enforceability methods as well. But if we didn't cover what you were looking for, please let us know. And then lastly, somebody submitted a topic request about verifying driver's licenses, U.S. passports, and foreign passports, which I think is a great sort of topic for discussion. I assume that person was looking for information related to, the application process when those are submitted and due diligence. So I'm going to get with one of my front-end lender colleagues and see what she has for information on that. And if you want to reach out to me about a little bit more specifics, we can get back to you and connect you with my colleague. And then additionally, we'll also consider putting on an additional webinar talking about, due diligence and perhaps better due diligence things to look for on your checklist for loan originations, which I know was a hot topic and lots of people phoned in on the first webinar to get information on that. So more information to come. And with that, I think, unless anybody else has any other questions, I don't see any popping up in the chat. We're essentially right at our 1 hour mark. So we'll close out for today. As a brief reminder, you'll be getting information about CLE that was submitted for this webinar forthcoming. And there will also be an evaluation form coming from Baker Donelson. We'd love if you took a minute to fill that out so we can better prepare for the next webinars. And stay tuned for, I guess, part 2 of part 3, the final webinar. And thanks for joining us today. Bye, everybody.